Renters' Rights Bill becomes law in the UK in October 2025. This literally happened yesterday. So what does it mean to you, landlords, today? It is scary stuff, but you need to understand what it means. Like and subscribe here. I'll share more information with you, but we are going to tell you what it means and how you need to change things to make sure you're okay. Now, this actually happened yesterday, which was 27th of October 2025, and now Section 21 no-fault evictions are going to be completely abolished. That's the first thing. Now, what this actually means is for years we've been getting our tenants to have short hold tenancy agreements, and we called them ASTs. There will be no more short hold tenancy agreements. When do we think this might happen? I'm going to predict April 2026 for it to be implemented fully. But guys, you need to get yourself ready. So instead of assured short hold tenancies, all tenancies for all tenants will be periodic tenancies, with tenants able to stay in their home until they want to end the tenancy by giving you 2 months notice. So what does this mean? This means no more 6 months minimum, and this means the tenant can give you 2 months notice at any time. So the idea is that it's supposed to end the injustice of tenants being evicted with no fault. But us landlords actually know that we've used that to help tenants on occasion. So tenants will suffer because of this change, but unfortunately, the government are implementing it anyway. So nothing we can do about it. All the fight is gone. This is what is going to be happening. So let me talk about some of the things that we need to do. So the massive change is in the past under Section 21, we were able to give 2 months notice to a tenant under something called a no-fault eviction. Now, I'm going to say probably from April 2026, you will need to go to court to evict a tenant. Now, I am also going to say that even if you serve a Section 21 now, if that tenant doesn't leave, you still may need to go to court to evict that tenant, right? Now, what we do have is Section 8 possession grounds, the current possession grounds, and they will be extended and reformed. However, the court system is going to be difficult, guys. We know this. So, what are those Section 8 possession grounds and how will they be reformed and extended? I'm not going to go through all of them, but I'm going to go through the really important ones that you need to understand at a high level. So the first one, if you as a landlord want to occupy the property or a family member of yours wants to occupy the property, the tenant, you can actually go to court and ask the tenant to be evicted. Now, this is a mandatory ground, and the grounds I'm going to talk about now are called mandatory grounds. And mandatory grounds have to be adhered to by the court if they are real and true, and they have to be real and true, okay? So you can evict a tenant in 4 months if you want to move a family member in or you want to move in yourself. Another one is if you want to sell the property. If you wish to sell the property, it cannot be used for the first 12 months of a new tenancy. So you cannot evict your tenants for a minimum of 12 months when they go into the property. But after 12 months, if you wanted to sell the property, you could actually sell the property. And again, it's a 4-month eviction process. Or how long the courts take. Properties rented to students for occupation by new students, okay? When a HMO is let full-time to students and it's required by a new group of students in the new academic year, you can evict those tenants. That is a mandatory ground, okay? The issue will be if one tenant refused to leave and you had to go to court. So this is, you would have to let them know in advance, 6 months in advance of the new tenancy starting, that they were going to be evicted. The next reason that you are able to ask a tenant to leave, and again it has to be proven, is the redevelopment of the property. The landlord wishes to demolish or substantially redevelop the property, which cannot be done with the tenant in situ. For example, a full back to brick refurbishment cannot be done with a tenant in situ. Various time limits or notice requirements will exist for this ground, and it's going to be up to you to understand it. The landlord must be the type of tenancy listed in the table on the government website gov.uk, which shows you more about the Renters' Rights Bill. Google Renters' Rights Bill, look at gov.co.uk. Okay, so you will be able to evict a tenant if the property needs a full refurbishment. You might need to provide alternative accommodation. So sometimes selling the property, if you do want to change things, that is going to be the only way you can evict tenants. Now let's talk about some of the other grounds that you might be able to evict tenants under. Okay, so the next one that we're going to talk about is decant accommodation. The tenant has been provided with alternative accommodation by a relevant social landlord. So for example, a council property. So again, 4 months before you can do that. Okay. Now, another ground is the death of the tenant. If the tenant passes away, okay, then the tenancy was passed on by will or intestacy, and the proceedings began within the requisite 12-month period, the ground can only be used if the new tenant wasn't living in the property immediately before the previous tenant died. So if it's a couple, you might actually struggle if the tenancy is in one name to evict a tenant that's the other person living in the property. So you have to have the correct supporting information. Look, we as landlords want to do the right things with our tenants, but we also need to be able to take possession of our property in certain circumstances. Now, we've got severe ASB and criminal behaviour. What is that? The tenant has been convicted of a type of offence. And again, we've got the right to prevent antisocial behaviour. So if that happens and there's antisocial behaviour, you could begin proceedings immediately. Another one is no right to rent. So if a person is in the property who has no right to rent under immigration law, that is a reason you can evict the tenant. And again, you can start eviction proceedings within 2 weeks, okay? There's quite a few of these mandatory grounds. The next one is rent arrears. If the tenant has at least 3 months, and it used to be 2 months, but now it's 3 months. Under the new Act, it's going to be 3 months. Rent arrears, at the time the notice is served, then you can evict a tenant, okay? We must ensure possession grounds are fair to both parties, giving tenants more security. This is what the government says, okay? I think tenants are going to suffer from some of this because some of us landlords were evicting tenants using Section 21 rather than saying that they were not paying their rent, for example, but you won't be able to do that in future. The only grounds we can evict tenants is under Section 8. Now, I want to start talking to you now about some of the other things that are relevant to the Renters Reform Bill and some of the other things that will happen. Now, there's going to be an ombudsman, okay? And there's also going to be a register of landlords, and all landlords will need to be, all of the properties will, so it's a private rented sector database, and all of our properties are going to be on there. So we have no choice but to put this into place, okay? Now, this bill is going to happen. It happened in Scotland quite a few years ago, and Scottish landlords tell me today there's not as many problems as you might have thought there would be with this situation. However, it's going to give tenants strengthened rights. We're going to have to apply a decent home standard to all private rented sector properties. And something really important that's happening is something called Awaab's law. And this is to do with mould in properties. So you really need to really understand what this means to you. But I think the biggest change is that we will now have to go to court to evict tenants. Another practice that's going to be ended is the practice of rental bidding. So we won't be able to go and allow a price war to happen when we are renting out a property. Another thing that's happening is you won't be able to increase your rent above market rent. So rent increases, and I don't know whether this will lead to rent controls. So we need to be really careful there, okay? So these are just some of the things that are happening under the Renters' Rights Bill. We have no choice but to adhere to these things, but you need to really research this. As I said, it's on the .gov website, and we will be reporting back here at titlesplit.com more information on this change.